So your question is, what is bail and how does bail work? Bail is regrettably a misunderstood concept in West Virginia law and probably throughout the country. What bail is a contract, an insurance contract that you enter into with a court upon your arraignment, which is your first appearance in front of a judge or magistrate. And that contract is to guarantee that you will appear in court for your designated hearing when the court sends you a notice of that hearing. That secures that you do not have to stay in jail while you wait your hearing and let your case unfold. Bail is a contract where you pledge money in a couple of different ways. One is to give it directly to the clerk of the court, and the clerk would hold that money for the duration of your case, and that money guarantees that you will show up. And if you do not, that money is forfeited. The more common way bail is used in West Virginia is that people will hire a bail bondsman who will pledge that money or guarantee that money to the court, but the bondsman will do it because the bondsmen have insurance policies in place, and they will charge a fee to a defendant and say upwards of the maximum fee is 10%. They will say, okay, you give me 10% of that bail, and I'll pledge it to the court through my insurance policy, and that will guarantee that you're going to come to the hearings. And then if you don't come, that would be skipping bail, then the bail bondsman is going to be responsible to pay that whole amount of bail to the court. That's the insurance contract that you enter into with these magistrates and judges when you are arraigned. Bail is only, however, to secure your appearance in court. It is not to be used as a punishment prior to conviction. And when somebody gets hired, their bail might be really high, and the first order of business in our firm is we address bail in many, many cases because it is too high. If somebody is incarcerated, we will file a pleading immediately and get a hearing within 5 days to ask a judge to reduce the bail and make it makeable. There are constitutional limits to bail. The bail has to be constitutional, and that means it has to be makeable. So depending on someone's income, if a bail is set to where it's just not makeable, well, that's tantamount to denying bail. And that's our constitutional leverage when we go into a court and we say, hey, you set a $50,000 bond, but my client simply doesn't have those kinds of resources. It's the same as denying bond. So we do advocate for bail reductions frequently, and we tend to get them. Not a guarantee, obviously, but we do have a great deal of success in getting bail reductions. And that allows us to then get somebody out of jail. Then, as a defendant, you have the ability to come to my office and sit in the comforts of our conference room without the pressures of being an inmate and without being in the courtroom to be able to really talk about the case and prepare the case and get it ready for trial. I far prefer when my clients are out on bail because we have the ability to have regular meetings at mutually convenient times to get the case ready for trial. So bail does have a constitutional dimension to it, and we will advocate for you to get a bail that's appropriate for you based on the offenses. There are a couple of offenses that we call capital cases for which bail is discretionary. It's not required, and we advocate to get bail in those cases just as well. So if you are in a situation where somebody or a loved one is incarcerated, unable to make the bail, the first call you should make is to Arnold and Bailey. We will address bail first thing. We will get a hearing within 5 days and get that number reduced to something that's reasonable. So don't hesitate. Contact Arnold and Bailey first and let us address bail for you.